Hello there, everyone. Today we're going to talk about interbranch conflicts during times of war. As a brief content warning first, we're going to talk about war. All right, so here we go. So wartime is different, but why? Especially when we're talking about the relative balance of power among the branches of government. Why is wartime different? Well, certainly, we think about the need for decisive action and secrecy during times of war. This is something, if you've ever tried to keep a secret among a group of friends, you know the more people are involved, the more difficult it is to keep a secret. And the same goes for making a decision. So, what happens with the courts? Usually, the courts have a relatively small role when it comes to wartime power. Why is this? A lot of times it's because the court is making decisions after the fact and is making decisions sometimes during the war, but after a particular incident has taken place. And the courts tend to defer to the judgment of the political branches, particularly the executive, for making these kinds of really difficult decisions on the fly. So let's talk about the prize cases. This is an 1863 case, and you read about it in your textbook. The material facts are something like this. President Lincoln started a blockade in an attempt to keep arms traders and others from supplying the rebellion or the insurrection in the South. And the owners of the ships got mad. So the legal question at issue here was whether the president has the power to institute a blockade during an armed conflict that hasn't been recognized by Congress as a war. So the court's holding here is a split decision, and the answer is yes. And the reasoning behind this is that the majority notes that a state of war exists. And this is true whether or not Congress actually names it a war. For this reason, the commander-in-chief, which is the president, has the duty to respond to this state of war. The president can call the militia in without Congress, and he has the power and can use this discretion as part of his power as commander-in-chief. Now, the dissenters obviously disagreed with this, and the main point was that this wasn't a war. And of course, you can see this is a very formalistic way of understanding what this power actually extends to, because Congress hadn't actually declared a war, and this means that the president's powers as commander-in-chief didn't come into play because the country was not technically at war. All right, so around this time, we also start to see quite a few cases dealing with military tribunals. So military tribunals are something that is run by the executive branch, not by the judiciary. And these military tribunals are often used either to deal with the behavior within the military, but also dealing with the people who have been detained. So, what do they say about the role of the court and the federal judiciary? Well, essentially, this has the potential to sideline the court or to keep the court out of the business of hearing appeals or dealing with these kinds of issues that come up in the tribunals. So our first example of this is in Ex parte Milligan. And of course, this is a case right around the time of the Civil War. And the facts of the case are like this. Milligan was a Southern sympathizer. He was an attorney and gave speeches, but he was in Indiana. He was arrested by the federal government and was tried in one of these military tribunals that Lincoln had authorized. So the legal question was whether a military tribunal could try a citizen during wartime for treasonous activities in a state that is not actually rebelling against the government. And the holding in this case was unanimous, and the answer was no. And this is because Milligan was a citizen, and he wasn't in a place that was under martial law at the time. This means he has a right to a trial by jury. They also commented on how glad they are that the war is over, and again, pointing out that Indiana wasn't actually under martial law, and so there was no reason not to avail themselves of the regular court system. Moving forward to World War II, we see another, in some ways, similar case dealing with military tribunals. And this is Ex parte Quirin, and this is in 1942. So the facts here are interesting. There is a sabotage plan, and 6 German citizens enter the United States to carry out these acts of sabotage. One of them ends up, I guess, getting cold feet and snitches to the FBI, which I find fairly interesting because maybe he thought the plan was so bad that it would be better to be tried in American courts as opposed to carry out the plan. I'm not sure what would lead somebody to do that, but in any event, the plot was found out, and it was stopped, and the people were arrested, and they were tried in military tribunals. They challenged this, and the legal question was whether the president has the power to create military tribunals to detain and try people accused of sabotage, espionage, or other warlike acts. And the holding here was unanimous. Yes, absolutely. Congress actually did declare war for this one. And unlawful combatants are not subject to prisoner of war status. And the court also noted that it is without significance that they didn't use conventional weapons. They asserted that Milligan doesn't apply because then they don't really explain it very well. It's likely that a lot of this has to do with the fact that these folks were not American citizens, or maybe that the conflict was still ongoing at this time. Moving forward to the Japanese internment, the key case in the Supreme Court is Korematsu versus United States. The case was decided in 1944. The material facts are like this. Executive Order 9066 actually started the Japanese internment. And Korematsu violated the enforcement order number 34. He was arrested, and it was at the time that he was in custody that he initiated the suit with the help of the ACLU. The legal question was whether the president can order the internment of all people suspected of being of Japanese ancestry while at war with Japan. The holding in this case was a 6-3 decision, and the answer was yes. The president may order the internment of all people suspected of being of Japanese ancestry. The court noted that this was seen at the time as being vital to prevent sabotage. And they argued that the president has to have the power to protect that fits the level of the threat that the country is facing. And they argued that there was some evidence that some Japanese Americans might have been disloyal, and so for that reason, I guess they thought that this was acceptable. Now, we had 3 dissents in this case. Murphy's dissent was very clear that this exclusion is absolutely racism. He argues that there was no martial law declared, and that the danger was not immediate, imminent, and impending. So this was far beyond the power of the president. Justice Jackson argued that there was absolutely no claim that Mr. Korematsu himself was disloyal. And what if he had been of German or Italian ancestry? Jackson points out, we were at war with them too. The court, he argued, is not bound to adhere to the military order. So we would think this is all ancient history. This is a photo from the Clinton administration era, and this is a picture of Fred Korematsu getting the Presidential Medal of Freedom. And it wasn't until, look at this, 2018. It wasn't until 2018 that the Korematsu decision was actually repudiated by the Supreme Court. And that happened in the context of the case about the Trump travel ban. And of course, in that case, the Supreme Court upheld the travel ban, but in doing so, they repudiated the precedent of Korematsu. So now let's talk really briefly about trying to find a balance here. How do we figure out who has the power when there is some conflict among the branches during wartime? And the court tries to do this in the case Youngstown Sheet and Tube versus Sawyer. In this case, the facts are, this happens during the Korean War, and in April of 1952, there is a steelworkers strike, and President Truman tries to seize the steel mills to get them back up and running in order to create the things that were needed for the war. So the legal question here was whether the president has the authority to seize and operate the steel mills during wartime. And the holding here was, again, a 6-3 decision, and the answer was no. The reason was pretty interesting. The court argued that the Taft-Hartley Act governs labor disputes, and this means that there is no statutory authority that would allow the president to do an end run around the cooling off period that was part of Taft-Hartley and move straight into seizing the steel mills. They argued that this was not happening in the theater of war, and so the power doesn't have anything to do with the president's role as commander-in-chief. And so there's no other place where the president has this kind of inherent or enumerated power. Jackson's concurrence in this case is particularly important, and we're going to see this come up again and again in these kinds of cases. And Jackson's concurrence gives us 3 different scenarios for understanding how much power a president has in these kinds of wartime situations. And first, he says, when the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate to him. And the second point is in the middle, when the president acts in the absence of either a congressional grant or denial of authority, he can only rely on his own independent powers, but there is a zone of twilight in which he and Congress may have concurrent authority or in which the distribution is uncertain. And then there's the third situation. And this is when the president takes measures incompatible with the expressed or implied will of Congress. His power is at its lowest ebb, for then he can rely only upon his own constitutional powers minus any constitutional powers of Congress over the matter. So what this does is it sets out this sort of 3-tiered situation where, depending upon the will of Congress, the president's power can be stronger or weaker. So the dissenters in this case, Vinson was joined by Reed and Minton, and he argued that presidents do this kind of thing all the time. And in fact, he talks about the fact that George Washington did something like this. He also mentioned that Franklin Delano Roosevelt did something very, very similar to this. And I don't know if you would catch this, but this is a little bit of a dig at Justice Jackson, because the Vinson's opinion, talks a bit about the then Attorney General Jackson going on and on about how FDR did actually have this power. Basically, the argument that Vinson's making is that this is one of those general grant situations where the executive power is a general grant of power, and this is included within that grant of power. There's also this really interesting kind of functionalist argument here, that if they don't allow the president this power, what is he supposed to do? He certainly can't pause the war to go ask Congress, and so he has to have this power to act decisively and authoritatively. All right, so in the next video, we're going to look at the way that Youngstown Sheet and Tube applies in some additional circumstances that we see dealing with foreign policy in the Middle East and the War on Terror. We're also going to see how the court responds when it gets pushed. And we'll see that the court doesn't really get mad, it gets slightly irritated though. And so we'll be paying special attention, not necessarily to disputes between Congress and the president, although that features very heavily in at least one of the cases. But we're also going to be focusing in a lot more on what happens when there is a dispute with the judiciary itself. All right, folks, see you back here next time.